Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson representing myself.
If this story sounds familiar, that is not an accident. This individual has made threats before lawsuits, judges, officers. Everyone is a target now. The focus is shifted to the traffic stop itself, a routine encounter turned into a legal fantasy. The strategy seems simple: overwhelm with words, hope the system collapses under confusion. But courts are designed for clarity, not chaos, and that becomes obvious very quickly. The claims escalate faster than the logic behind them. Nothing new is being introduced here, just recycled arguments with louder delivery. The court has seen this script many times, and it rarely ends well for the person reading it. So let's watch how the judge handles it, because this response is textbook.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. All right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't have jurisdiction?
There is a certain confidence that comes with misinformation. It shows up early, and often in hearings like this, the speaker believes tone can replace substance, but courts do not respond to attitude. They respond to rules, procedures, and precedent. Mockery may work online, but not under oath. The contrast is immediate and uncomfortable. The judge stays focused while the argument wanders. Camera confidence does not equal legal competence, and the gap becomes painfully clear. Every sentence creates more problems than answers. Nothing is being clarified, only complicated. The court allows the speaker to continue, not to help, but to establish the record, because once the record is clear, the outcome becomes inevitable.
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismissed in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
This is where the logic completely collapses, claiming no jurisdiction while demanding relief using the court while denying its authority. It is a contradiction that cannot be fixed, and the judge sees it immediately. You cannot reject the system and ask it to serve you. That argument dies the moment it is spoken. The confusion on display is not legal nuance, it is fundamental misunderstanding. The judge presses for clarity and gets none. Every answer creates a new contradiction. This is not strategy, this is improvisation, and improvisation fails in structured environments, especially courtrooms governed by rules. The judge does not argue, he documents, and documentation is deadly to bad arguments.
Well, certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive plea. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. I started off Brian Ambrosius stopping me, and I believe I have the right to travel. It started with that.
We have seen this exact playbook before. File motions while denying authority. Quote, cases that do not apply hope. Repetition turns fiction into fact, but courts do not operate on hope, they operate on jurisdiction and procedure. The judge explains this calmly and clearly, yet the message does not land. The argument circles. Instead of progressing, nothing connects to an actual legal claim. This is where prior cases become irrelevant because context matters more than confidence. The judge is not dismissive, he is precise, and precision exposes every weakness. There is no mystery left in this case. only the question of how it will end.
And I do understand the default judgment, what do you that you are saying, and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michaels, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiff, and it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to travel.
At this stage, the hearing shifts tone because the court has heard enough not out of frustration, but clarity. There is nothing left to explain. No factual dispute has been presented. No legal cause of action has been stated. The argument exists only in theory, and courts do not rule on theory, they rule on law, and facts, both of which are missing here. The judge gives one last opportunity, not to argue but to clarify, and that opportunity is wasted. The response only deepens the problem. This moment seals the direction of the case. Everything after this is formality.
All right, I got it. All right, that you failed to state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides. I wish you well.
This is where reality finally enters the room. The court asks a simple question: what exactly is the claim? And the answer goes everywhere except forward traffic court, civil court, common law. Everything is mentioned except jurisdiction. The misunderstanding is now undeniable. The judge listens, but does not interrupt because letting it play out is important. The record must be complete. Even when the argument is not, there is no malice here, just confusion. Confusion dressed up as certainty, and certainty without knowledge is dangerous, especially in legal settings. The court cannot fix misunderstanding. It can only rule on what is presented, and what is presented does not survive scrutiny. And that brings us to the end of this hearing. Another courtroom lesson: fully documented confidence alone does not win cases. Knowledge, preparation, and law do. This is why legal advice from the internet fails and why courts remain structured environments. If you enjoyed this breakdown, make sure to support the channel. Your engagement keeps this content coming. These cases are important to understand, not to mock, but to learn from, because misunderstanding the law has consequences, and courtrooms are where those consequences appear. Thank you for watching all the way through. Let me know your thoughts in the comments. Subscribe if you want more courtroom analysis, and as always, stay informed and stay grounded.